The first case to come before the court is State of Ohio v. John Herring III. Each party will have up to 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium. Keep your voices up. Introduce yourselves. You should not use the names of children or victims or minors should that be relevant to your argument. You may use initials or generic terms. We have read your briefs and we're ready to proceed when you are. And I would just ask the appellant, would you like to reserve time for rebuttal?
Yes, please. I'd like to reserve 5 minutes.
Very well. Then you may start when you are ready.
Thank you. Just keeping my clock here also.
Sure.
Good morning. I'm Kimberly Kendall-Carroll on behalf of the appellant John Herring III. I think this case really highlights how small errors compounded together create an unreliable result which warrants reversal in this case. Here, John Herring was essentially found guilty because officers came in and told the jury that he was. The evidence that came in didn't come in from its original sources and it wasn't reliable. And there's a number of ways that happened, but essentially officers testified to the jury that he assaulted someone. Officers testified to the jury what other witnesses who didn't come into court said. Officers improperly identified Herring on a video, which wasn't clear. It invaded the province of the jury. Officers improperly identified his voice. And then, on top of that, the court made a number of rulings that it failed to follow through with. And so I'd like to start by talking about confrontation, the confrontation clause, which invaded this trial in violations of the confrontation clause, which invaded this trial in numerous ways. The first is that Herring was not in the courtroom for a majority of the pretrial procedures and no waiver was executed. Absent a waiver, that is a violation, and it's absolutely prejudicial in this case because he was unable to communicate with his counsel during pretrial procedures. And we all know how important it is, as attorneys when we're dealing with cases, sometimes having not lived it the way a defendant lives it, you don't have everything. So the ability to speak to your client during a hearing is necessary.
Counsel, am I correct in saying, as I see the record, it says that the parties agreed to having these hearings by Zoom. Was there an agreement to proceed on Zoom?
There's no agreement on record. There's a statement that the parties agreed, but a waiver is required under Criminal Rule 43, and that waiver must be made by the defendant, and it must be knowingly, intelligently, and voluntarily made, which means that necessarily on the record, either the judge or his counsel would have had to say, here are your rights. By appearing via Zoom, you're waiving those rights. Do you understand those rights? And that didn't happen. And it's crucial, and the prejudice is also in the record because he tries to speak specifically to his counsel about a confusion of facts, and he's admonished by the judge. The judge says, well, what you said was helpful there, but you shouldn't be saying things because he has no ability to speak to his attorney contemporaneously without announcing whatever he's saying also to the court and to the state. And so that's like the first way that the Sixth Amendment was violated.
Let me just follow up with Judge Stevenson's question. How do we know that from the record that there was no ability?
Oh, how do we know that from the record? Let me find the page number, but he's trying to speak on the record, and the judge states, you should be quiet, something towards the effect of, I have it quoted in my brief.
I remember reading that, but I guess what I'm saying is, how do we know, is there something on the record that indicated that he didn't have the ability to tell the judge, I want a private time with my attorney, or had a breakout room, or whatever there was?
The record has to establish that he had the means for his rights to be accommodated, and it doesn't. So the absence of that in the record is why it's a fatal flaw and requires reversal. But that said, had that been available, the judge would have said, you know what, if you do need to talk to your attorney, let me put you in a breakout room. He doesn't do that. He says, be quiet. Don't say anything that might bite you or burn you later, I think is the language. Even though the judge acknowledges that what he had to contribute was helpful. And so we know he had things he wanted to say to his counsel that he frankly couldn't, and the record establishes that. The next way that the Sixth Amendment is invaded is the appearance of witnesses via Zoom. Now, obviously, COVID really changed procedure in American courtrooms, but it didn't invalidate the requirement that witnesses show up. And they were allowed to testify via Zoom over defense objection and without a proper record about the need for Zoom testimony being made. Next, and the names of the officers are escaping me, but the girlfriend and the mother, the girlfriend, the alleged victim in this case, didn't come into court. And so any testimony about what she said or what her mother said to officers is coming in violation of confrontation. It's not enough to say that there's an excited utterance, although I want to talk about how the trial court allowed that issue to failed as a its gatekeeping function by instructing the jury that it should determine whether there's an excited utterance. But that exception doesn't apply where the witness is unavailable and the nature of the statement is testimonial. The only thing linking him to that gold Cadillac was that his girlfriend and her mother said he drove away in it. The only thing that establishes an assault is testimonial statements from the girlfriend and the mother, and they didn't come in. And they didn't come in because the court indicated they would bring them as witnesses, but then it didn't. But that's the state's burden, and the state rested before they came in. And without that improper evidence, essentially the majority of these counts fall. So the prejudicial effect is enormous in this case. And it's not that they just testified to what was said, but one of the officers testified to the legal conclusion of assault. That's where she was assaulted. That's a determination for the jury to make, and in testifying a legal conclusion, she invades the province of the jury. And so we see how all of these multiple confrontation clause issues, which come in different ways, by video Zoom, by remote participation, by improper hearsay testimony, really undermine the reliability of this conviction and require reversal. Another thing that happens in this case that I think is important to address is the way in which the trial court transferred the gatekeeping role of the court to the jury. And he did so when he explained to them that typically hearsay isn't reliable, but when it's an excited utterance, it's extra reliable. So if you find that it's an excited utterance, then you can give it weight. That's not how the rules.
Counsel, did the court actually say it's extra reliable?
I think they said it's more reliable.
More reliable than
Hearsay,
I gotcha.
other hearsay.
I understand.
And I don't mean to misquote, but the tone and intent of the comment was to say that because it's excited utterance, we give it credibility where otherwise hearsay is less credible. Right, and it gets admitted. And I think he says more than it gets admitted. But the issue there is that the gatekeeping function of the court is supposed to, one, consider the four prongs first and decide whether it gets admitted. The jury shouldn't have heard it until that decision was made, until that weighing happened, and then the jury shouldn't be in the position where it's determining whether it is in fact an excited utterance or is not an excited utterance. And so it's transferring the gatekeeping function to the jury, and the jury is then supposed to decide, one, whether it's an excited utterance or not, and two, whether or not they should consider it. That's the role of the court. And he's basically saying the likelihood that the information that's being provided could be reliable is recognized by law. So he's giving extra weight and consideration to the reliability of these hearsay statements in instructing the jury as to what excited utterance is.
Is that in effect performing the gatekeeping requirement that you're talking about, the judge not performing?
No, the Ohio Supreme Court is clear that the trial court should make the determinations weighing the four prongs of whether something is an excited utterance. He specifically says, therefore, can be admitted for the truth of what was stated during that excited utterance, assuming that that you, as a jury, find that she was indeed excited and that the utterance came as a result of that excited state and that she was in, which totally ignores the fact that the court also has to consider whether it's testimonial in nature, and frankly, it was testimonial in nature, so the witness was not available for cross-examination, and so it shouldn't have come in anyway. You understand, literally no factual witnesses were available for cross-examination by this defendant. So his confrontation clause was entirely undermined by the effect of all of these errors. Additionally, the bifurcation of the counts in lieu of actually severing the cases created the result where evidence which was other acts evidence prejudicial to the defendant.
We're at 5 minutes, just so you know.
Oh, okay, I'll reserve my time, thank you.
Good morning, may it please the court. Lindsay Paprocki of the Lorain County Prosecutor's Office for the state. John Herring here was indicted on 15 counts for offenses which occurred on 2 separate days. I'll just touch on what counsel was touching on at the last portion of her argument regarding the severance. And here, Herring made a motion to sever the accounts in the indictment based upon the separate dates in the indictment. And his first assignment of error focused on the fact that the trial court abused its discretion when it granted his own motion to sever. And there are 2 problems with that argument. And that is, not only has Herring failed to preserve that issue for appeal, but any error related to that issue was invited. The trial court granted Herring's motion on the record after a hearing. And because Herring obtained the very relief he asked for, he didn't object after the court granted his motion, and he rather complains about it for the first time on appeal. Here the proceedings proceeded in the way that Herring requested, and he has not been prejudiced by that in any manner, and he cannot take advantage of any error from which he invited.
Counsel, I understand your argument. It seems like the defendant is raising the issue in this way, that it was merely a bifurcation of the counts and not really severance. In other words, it wasn't a separate trial.
The state would just submit that in the way that he's argued this, he's not permitted to argue this on appeal because he never objected. He obtained the relief that he sought, and this would be subject to a plain error review, and he has not argued plain error in his brief. And this court has repeatedly made clear that it will not create a plain error argument on behalf of an appellant who has not argued plain error in his brief. So for that reason, we would ask the court to reject the severance argument and move on to the arguments regarding the pretrial waiver argument and the fact that hearings were held outside the presence of the defendant. And as Judge Stevenson has noted, this assignment of error focused on the suppression hearing. And there is an entry in the trial court in the record that was issued by the trial court indicating that the suppression hearing proceeded to hearing that was conducted via Zoom via agreement by the parties, and that was due to the global pandemic. And even if it can be argued that this did not qualify as a criminal 43 waiver, Herring again did not object to the hearing proceeding via Zoom at any point. And again, the hearing proceeded in this way, and there was no objection. This plain error argument again applies because of no objection. This is this plain error issue plagues hearings appeal. The same can be said about his complaints, this Detective Franco, about Detective Franco's remote testimony. Because he agreed to the hearing proceeding via Zoom, he didn't object to Detective Franco's remote testimony. He was aware that the matter would proceed via Zoom, and in that regard, Detective Franco would testify via Zoom.
Is there any filing on the record or any statement at the suppression hearing in which the defense counsel or defendant indicate they're agreeing to proceed by Zoom, or just merely the trial court statement that they agree?
I believe it's just the trial court's entry. I don't believe that there is anything during the hearing. That is correct. I'd like to then focus on the trial that proceeded on the several separate counts and the excited utterances that came in from the victim and her mother. The bulk of the testimony here came through Officer Gentry, who testified that the initial dispatch call for these offenses was in reference to a domestic violence call that was in progress. And Officer Gentry responded to the home within 3 minutes of that call and was met by the victim and her mother, who both provided statements about the incident, while they were under duress, which related to the incident that had just occurred. And Officer Gentry also photographed the victim. Now, neither the victim or her mother appeared for trial, and a number of hearings assignments of error relate to the admission of their statements through Officer Gentry's testimony. The trial court properly admitted these statements under the excited utterance exception and properly exercised its discretion to do so. And while hearing claims that these statements were testimonial in nature, this argument fails, as the Ohio Supreme Court has noted that where statements are offered to explain an officer's conduct while investigating a crime, these statements are not hearsay. Here, Officer Gentry's testimony relayed why she began an investigation into hearing. Her further testimony was offered to explain her actions in taking photographs of the victim's injuries, and to the extent that that testimony continued, Officer Gentry proceeded to identify photographs of the victim's injuries, and the judge properly ruled that at that point, Officer Gentry was testifying to her conduct, to the statements as they related to her investigation and the actions that she took in furthering the investigation. She was not seeking to develop testimony about past events for purposes of testifying in a criminal proceeding, whether she was responding to a developing situation where a hearing had fled and such that the admission of the challenge testimony statements was not testimonial.
When the objections were raised below about this testimony, was the objection that this was in violation of the Confrontation Clause raised at that time? In other words, an objection hearsay, they also did with an argument that's violating the Confrontation Clause at that point?
I don't believe that there was an objection regarding the Confrontation Clause per se. There was an objection to the statements. There was an objection to the statements coming in when, I believe, under the excited utterance, for purposes of excited utterance, but I think the record would clarify that itself.
The explanation, I'll call it the explanation, kind of
Sure.
instruction the judge made as to jury, this is excited utterance, and here's what that means.
Sure.
When the final jury instructions went to the jury, when they decided to deliberate, was there any instruction about hearsay or excited utterance in those jury instructions? If you recall.
I cannot recall, but our position on the explanation that was given to the jury is that, again, that falls under plain error, because at the time that the judge made that explanation or comment on the hearsay, the excited utterance, the explanation on excited utterances, there was no objection by defense counsel as to that comment being made. And since there was no objection being lodged at that point, plain error would apply. And because plain error hasn't been argued in the brief, this court can't this court can't develop an argument on behalf of the appellant for plain error.
Counsel, in regard to that, I understand again your argument that they haven't raised plain error, but you would agree, right, that you can't tell the jury that they can decide whether the evidence is admissible. That's the job of the judge.
It's within the discretion of the judge, correct?
Right, they make their determination as to what evidence is admissible.
Correct.
Thank you.
Our argument is procedural argument.
I understand.
Correct. If there are no further questions, I would just submit on our briefs.
Hearing none. The appellant may take her time for rebuttal. You got 4 minutes and 53 seconds.
Thank you. First, I want to say that the defense counsel did object. There were not speaking objections and all objections in this court. A lot of them are just plain objections. So to say objection here, say also objection confrontation, that's not the procedure that this trial court moved forward with. They were largely not speaking objections, just objections. There were objections to all of the hearsay that came in, and it's our belief that the objection to the admission of that improper evidence, once made, he doesn't have to re-object every word that comes out as the judge is then giving improper instructions. There was a whole sidebar about how that shouldn't happen. So the fact that another additional objection wasn't announced doesn't waive the defendant's ability procedurally to raise these errors.
Just so I understand, after the judge gave his explanation, instruction, whatever you wish to call it, regarding excited utterance, was there some objection by the defense counsel? Was there some sidebar? I don't recall from the record. If there was any discussion at that point, after that was stated, did defense counsel object and wish to talk about that?
No, he objected to it coming in at all to the jury.
The judge's instructions. So did anyone, at that point, the judge gave these instructions, explanation, whatever you wish to call it. When that is all done, did defense counsel say objection?
I would have to review the record.
Fair
Yeah,
enough.
I would have to review the record. But my position is an additional instruction is not required to preserve the issue. The issue is already preserved. I do want to talk about the motion to withdraw the plea. I think the court understands our argument is that the court, regarding the bifurcation, the court granted severance, and severance is different than bifurcation. They should have been severed into two different cases. But I want to talk about the motion to withdraw the plea. In this instance, the plea warranted withdrawal under the right standard. They put on evidence that they didn't have all of the information related to the counts at the time they made the plea, that new evidence had become available. The judge acknowledged that in the record, and then the judge used language that it considered its own arbitrary standard. There's not a legitimate basis for withdrawal. He's not going to grant it for a tactical advantage, a change of heart in order to gain a strategic advantage going into the next trial. But this is not the standard. A plea made pre-sentencing should be freely given. That's the language of the rule, and it should be offered to correct a manifest injustice, and when a plea is not knowingly, intelligently, and voluntarily made. There was not a consideration of whether it was knowingly, intelligently, and voluntarily made by the court, but the defense did put on evidence that it could not have been knowingly, intelligently, and voluntarily made because they didn't have the evidence that the state had not yet turned over. The discovery was turned over later in order to have made the determination about the plea. It couldn't be knowingly, intelligently, and voluntarily made when they didn't know the information related to the plea. The state's argument that an officer can testify basically to things they did not see or did not observe as an exception to explain why they opened an investigation If you follow that logic, we just wouldn't need fact witnesses anymore. We could just have, it would be like grand jury, we would have officers come in, say what they saw. Nobody would have any right to confrontation. I mean, that interpretation of that rule, it wasn't admitted to show why she, I think that's a pretextual argument. There's no doubt that what Gentry testified to was not admitted to establish why she investigated Herring. It was admitted to establish that Herring assaulted somebody. It was admitted for the truth of the matter asserted, and it denied him confrontation of the witnesses involved in the matter, the people who were there, who alleged that this happened to them. And so I don't think any of those issues are overcome by some procedural complaint of plain error. There were objections made throughout here, and some of these issues are raised as plain error in the brief. I think this court is bound by the law to reverse and remand this case based on not just the individual errors, but the cumulative errors and the effect of those errors. And nothing further, unless there are questions.
Hearing none, thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it's released, and it will also be posted on the Ohio Supreme Court website. Thank you both again.
Great, thank you.